Today, let us take up the topic possession in legal theory and jurisprudence. So, whenever we say about a land, that is immovable property or a movable property, there are two things involved in that. One is called ownership and the other is called possession. When the title deed is there, then the ownership is ascertained, and at the same time the owner possesses the goods. He took the possession of the land or the goods, then he is the absolute owner. The right in rem is assured. So that is we are going to see in this topic about the possession. Ownership is there already because of the title deed. And what about the possession? When the owner gives the land or the movable material to others for use or giving to others on higher basis, then the ownership rests with one and the possession rests with other. ஒருவர் ஒரு பொருளை நிலத்தையோ அல்லது பொருளையோ தன் கையகத்தை வைத்திருக்கும்போது அவரிடம் அதற்கான டைட்டில் டீட் இருக்கிறது. அதனை அவரே வைத்திருந்தால் அது மிகச்சிறந்த ஒரு அவரிடம் இருக்கிறது. ஆனால் அதை அந்த பொருளையோ அல்லது நிலத்தையோ வேறு ஒரு இடத்திற்கு ஹையர் பேசிஸ்லையோ அல்லது டெனன்சி ரைட்டு கொடுத்தோ அவ்வாறு கொடுக்கும்போது பொசஸர் ரைட் ஒருவரிடம் இருக்கிறது, ஓனர்ஷிப் டைட்டில் டீட் இருக்கிறது. ஒரு கண்டிஷன் பேரிலே அவ்வாறு தரலாம். அந்த கண்டிஷன் முடிந்த பிறகு மறுபடியும் அந்த லேண்டையோ அல்லது பொருளையோ ஓனரிடம் ஒப்படைப்பது சட்டப்படி அது செல்லுபடியாகும். So now we are going to see about the nature of the possession. Possession means the capacity to deal with a thing physically. What a person can do with a thing physically, that is called possession. Then in order to have peaceful enjoyment of their material thing, possession is needed. So whenever a person want to enjoy the property, then material possession is needed. Though he may not have the ownership, but material possession is to be given, is to be ascertained by deed. That is called possession. So possession neither purely legal or purely a factual. It is not neither a legal or factual. For example, illustration, I may own a car, but when I give it to other for hire, then the possessive right is with the person with whom I delivered the car for a price, for a higher basis. That is, then another illustration, the car was purchased on applying bank loan, the EMU is remitted. So whenever if he fails to remit the EMU, then the bank have the right to take back the possession of the car. So only the ownership and possessor right transfers to a person who fulfill all the installment along with interest to the bank. So that is the illustration. Then lawful possession is also protected. So Geneva, it prevents it aids criminal law by preventing peace, as interference with possession as always invited violence. So to avoid some violence, the interference is needed. So that's why it aids criminal law. Then possession is protected as part of law of tort. So unlawful possession is also sometimes protected. Then possession and ownership. So these three things involved: custody holder, detention, and ownership. Custody holder means whenever land or object is with a person, he is called custody holder. He lacks full control of thing or has no intention to exclude others. So the others may also can have some right over that. That is called custody holder. Then detention. Full physical control is with a person. In fact, this is called detention. This is not regarded as possession in law. Then another thing, possession, legal possession. Whenever he possesses the property legally, that is called possession. Then next thing, what is the difference between ownership and possession? The rights which can be owned but not possessed because it is transited. Sometimes the rights is can be owned but not possessed. In case of B owes rupees 10,000 to C. That is B give loan to C rupees 10,000. So C has to pay the B. So C is called the creditor, owns the right to recover the debt, but it cannot be possessed. So only the creditor can have the right to recover the debt, but it cannot be possessed. Then characteristic of possession: power to use continuous control. That is, whenever the property is in possession with others, he should have control over the property. That is called. Then the power to exclude other people, that is called animus possidendi. Then corpus possidendi means power to use and hold. So whenever a person have power to use and hold, then it is called corpus possidendi or corpus version. Possession in law, that is crime of larceny, that is the theft of others' goods is called larceny. So a cupboard is purchased, but the seller may not be knowing that some valuable is in the safety locker. So the valuable hidden in secret drawer, seller never intended to give the possession of the valuables. Then physical possession is less than, that's why it is called physical possession is less than the legal possession. Then possession in law without knowledge. Sometimes without knowledge the possession is there. That is, possession is in law without knowledge. For example, when a ring is in the pool, that is swimming pool, somebody might have, suppose if a ring is dropped in the pond by somebody, then that article is taken by somebody, he may not be the owner of that. So that is called the larceny. That is, ring in pool, lost articles are deemed to be in the possession of loser. So that is the lost article by somebody. So the actual ownership and possession should be lie with the actual owner and not with the person who possesses it or who has taken it. That is called larceny. Then possession, a temporary title. It is not a permanent one, it is a temporary title, because the possession is given to others by the ownership on some title. It may be on hire, it may be on lease or for some other purpose. Kinds of possession: immediate and immediate, corporeal and incorporeal possession. Immediate possession means whenever a person purchases a good from the shop, the right of property transfers, the right of property transfer to the buyer from the seller. That is called mediate possession. Immediate possession. Mediate possession means whenever a person orders a book and asks a friend to purchase a book for him, then the friend purchases the book for his own friend, it is called mediate possession. Then he transfers the book to his friend. That is called mediate possession. Then corporeal and incorporeal possession. That is, possession of land is called corporeal, and possession of right of light, right of air, like that, that is called incorporeal possession. Corporeal means that is physically holding is called corporeal possession. Then the last one is remedies. Whenever any problem lies with the possession and ownership, suppose the possess right with somebody, and if you continuously hold it without giving back after the period of the lease or hiring is over, then he is possessing without any right. Then the owner can sue the person who is having in possession. So this is institution of suit is the remedy for any problem arises with the possessor right or in ownership right. With this we conclude this video.